They handed me the termination letter at 4:47 p.m. on a Wednesday. I read every word twice, signed 3 copies, collected my belongings and walked out. At 2:13 a.m. my phone erupted with an unknown number. The voice on the other end belonged to their senior counsel and it was shaking. "Ms. Holt, please tell me you didn't actually sign those documents." I smiled in the darkness of my bedroom. "I signed exactly what you presented to me. You might want to check Section 7, subsection C. Terminations based on performance deficiencies require documented performance improvement plans attached as appendix materials. I see no appendices. Your move." Before we continue, please subscribe to the channel and write in the comments what city you're watching from so I can see how far my story has reached. The termination package sat on my dining room table at 11:23 p.m. that Wednesday night. 3 identical copies, each one signed with my full legal name. Maren Elizabeth Holt. Every signature line executed. Every initial placed where those ridiculous yellow taps indicated. I'd spent 47 minutes reading through all 28 pages of legal documentation that Apex Dynamics had prepared for my departure. The severance terms were mediocre but acceptable. 18 weeks of pay, 1 week for each year I'd given them. Health insurance through March. Standard non-solicitation and non-disclosure language. What caught my attention wasn't what they'd included. It was what they'd forgotten to attach. Section 7, subsection C, buried on page 9 between clauses about intellectual property and company equipment return. In cases where termination results from documented performance deficiencies, this agreement shall incorporate by reference all performance improvement plans, warning notices and evaluative materials relevant to said deficiencies, attached herein as Appendix B and forming the factual basis for separation. I'd written that language myself 4 years ago when I'd been promoted to Vice President of Strategic Operations and had been asked to overhaul Apex's human resources policies. Too many talented people had been dismissed on vague accusations. Too many careers destroyed with no paper trail, no accountability, no recourse. So I'd built protections into the system. Protections that required documentation, evidence, due process. Protections that Apex's HR department had apparently forgotten existed when they decided to fire me for consistent performance deficiencies and failure to meet operational benchmarks. My phone lit up the darkness. Unknown caller. Area code 617. Boston. Where Apex maintained their legal operations center. I let it ring 7 times before answering. Maren Holt speaking. "Ms. Holt, this is Liam Callahan from Apex Dynamics Legal Counsel." His voice carried a tremor I'd never heard in our previous interactions. "I apologize profusely for the late hour, but I need to ask you something urgent about the separation documents provided this afternoon." "I'm listening, Liam." Have you executed the non-disclosure provisions of the termination agreement?" I glanced at the papers on my table. My signature on page 22. Directly above the NDA section. "I signed everything Apex provided me, exactly as your HR director specified." "Ms. Holt, I need you to understand something critical. There may have been a documentation error in the materials we supplied. We're prepared to offer you a chance to review revised paperwork." "What sort of error?" My voice remained perfectly neutral. "I'm not at liberty to discuss specifics telephonically, but if you haven't yet executed the agreement, we'd appreciate scheduling a meeting to address certain corrections." I executed all documents at approximately 7:15 p.m. this evening. I scanned the completed package and transmitted it to your HR department at 7:38 p.m. "Is something wrong with your documentation?" The pause stretched long enough that I wondered if the connection had dropped. Background voices filtered through. Someone was conducting an emergency meeting at Apex's legal offices at 2 in the morning. "Ms. Holt," Liam's voice returned tighter now. "Can you clarify what you mean by executed all documents?" "I mean I signed the separation agreement as presented. Every page initialed where indicated. Every signature line completed. The full 28-page document that HR Director Grace Stevens provided during my termination meeting at 4:15 p.m. today." "And the appendices? Did you review the attached appendices?" "What appendices?" The document I received contained no appendices. Just the 28-page separation agreement. Another extended silence. I heard someone curse distinctly in the background. Then Liam's voice, barely maintaining professional composure. Ms. Holt, the separation agreement should have included appendix materials. Specifically, if termination was classified as performance-based, there should have been performance improvement documentation attached as Appendix B. Should have been, Liam? Interesting phrasing. Because according to Section 7, subsection C of the separation agreement I signed, performance-based terminations must be accompanied by PIP documentation. Not should be. Must be. Quote, this agreement shall incorporate by reference all performance improvement plans, warning notices and evaluative materials relevant to said deficiencies, attached herein as Appendix B and forming the factual basis for separation. End quote. Dead silence. I count 0 appendices attached to the document I received and signed, I continued. Which means either my termination wasn't actually performance-based, in which case you need to explain why your termination letter explicitly states consistent performance deficiencies, or my termination was performance-based, but you failed to provide the mandatory documentation, rendering the separation agreement invalid because it violates your own contractual requirements. Ms. Holt. Either way, Liam, I believe we'll be seeing each other in court. I suggest you get some rest. Tomorrow is going to be exceptionally long for Apex's legal team. I ended the call before he could respond. My husband Elliot had been listening from the hallway. You planned this. I planned for the possibility they might terminate me without following proper procedures, I said. I wrote those procedures specifically to prevent what happened today. Vague performance accusations with no documentation, no improvement plans, no objective metrics. What happens now? Now we wait to see if they attempt to fabricate documentation retroactively, which constitutes fraud. Or claim the appendix materials aren't actually required, contradicting their written policy. Or try to settle this quietly before it becomes public knowledge that they systematically fire people without proper documentation. Which outcome do you want? Honestly, I want them to take me to court. Discovery in a wrongful termination lawsuit would expose how many others they've dismissed using identical vague performance accusations without proper documentation. I'm betting that number is substantially higher than Apex wants their investors to know. Let me establish who I am and how I arrived at this point. Maren Elizabeth Holt. Age 44. Bachelor's in Industrial Engineering from MIT. Master's in Business Operations from Wharton. MBA from Columbia. 19 years in Corporate Operations Management. The last 14 at Apex Dynamics, progressing from Operations Manager to Vice President of Strategic Operations. I'd overseen 32 major operational initiatives during my tenure at Apex. Initiatives that had generated approximately $640 million in cost savings and efficiency improvements. I'd restructured the supply chain division, reducing overhead by 23%. I'd implemented automated quality control systems that decreased defect rates by 41%. I'd built the Strategic Operations Department from 9 people to 78 people. For all those contributions, I'd been terminated at 4:47 p.m. on a Wednesday afternoon for consistent performance deficiencies that nobody would actually specify. The termination meeting had been brief and uncomfortable. Grace Stevens from HR and Owen Ashford, the new chief operating officer who'd been hired 6 months ago from a competitor. Owen was 39 years old, had an MBA and consulting background, and had made abundantly clear from day one that he considered Apex's operational approach outdated and overly bureaucratic. Maren, we need to discuss a serious matter regarding your performance, Owen had begun, staring at his notepad. What performance issues? I'd asked directly. Multiple stakeholders have raised concerns about your operational outcomes and management effectiveness. After thorough consideration, we've determined your performance doesn't meet Apex's standards. We're terminating your employment effective immediately. What specific performance deficiencies are you referencing? The specifics are documented in your personnel file. What matters now is transition planning. I'd like to review that documentation of alleged performance deficiencies. That's not necessary for this discussion, Grace had interjected quickly. We're prepared to offer you a separation package if you sign the agreement today. They'd slid the document across the conference table. I'd taken 35 minutes to read it thoroughly while they sat in uncomfortable silence. The terms were standard. 18 weeks of severance. Benefits through March. Standard non-compete and non-disparagement language. But what had captured my attention was the termination classification. Termination for cause, performance deficiency, and the complete absence of any attached performance improvement plans or evaluative documentation. I'd signed it anyway. Initialed every page. Executed every signature line. Because I knew something Owen and Grace apparently didn't know. Their own policy required PIP documentation for performance terminations. By signing an agreement that lacked those materials, I was documenting their policy violation. Thursday morning at 8:14 a.m., I received an email from Liam Callahan. Ms. Holt, following our conversation last night, Apex Dynamics would like to offer you the opportunity to meet and discuss revised separation documentation that addresses certain procedural oversights in the original materials. We believe revised documentation would serve both parties' interests. Can you be available Monday morning at 10 a.m. at our offices? Regards, Liam Callahan, Senior Counsel, Apex Dynamics. I forwarded the email to my attorney, Elizabeth Rains, who specialized in executive employment litigation and had represented numerous corporate executives in wrongful termination disputes. They're panicking, Elizabeth said when I called her 15 minutes later. They realized they terminated you without following their own procedures, and now they want to fix it after the fact. Can they do that? Not really. You already executed their agreement. They accepted your signature by processing your termination. They can't now claim the agreement was invalid simply because they made documentation errors. Either the agreement is valid as signed, meaning they violated their own policy, or the agreement is invalid, meaning your termination is also invalid. So what should I do about this meeting? Attend the meeting. Bring me with you. Let's see what they're willing to offer to make this disappear. Monday morning, Elizabeth and I arrived at Apex's headquarters at 9:52 a.m. We were escorted to a large conference room where Liam Callahan waited with two people I didn't recognize. A man in his 50s who introduced himself as Nolan Schwartz from Apex's outside counsel firm, and a woman in her mid-40s who turned out to be Diane Kelton, Apex's chief financial officer. Ms. Holt, thank you for coming, Liam began. I think we can resolve this situation constructively. I'm listening, I said. Nolan Schwartz opened a tablet and pulled up a document. We've prepared revised separation documentation that addresses the procedural issues with the original materials. The revised agreement includes the performance improvement documentation that should have been attached to the original, properly documenting the performance deficiencies that led to your termination. You created performance improvement plans after the termination? I asked. We obtained written documentation of performance concerns that had previously been communicated verbally. We're now providing them in written form as required by policy. Elizabeth leaned forward. Mr. Schwartz, performance improvement plans for a termination should be created and implemented before the termination, not fabricated afterward. Creating them retroactively to justify a termination decision that's already been executed is not consistent with proper employment procedures. The documentation reflects genuine concerns that were communicated to Ms. Holt prior to her termination, Nolan said carefully. Then why wasn't it documented at the time? Elizabeth asked. Why wasn't it attached to the original separation agreement as required by Apex's own policy? There was an administrative oversight. We're correcting it now. An oversight that happened to benefit Apex by allowing them to terminate Ms. Holt without providing required documentation. Convenient. Diane Kelton spoke for the first time. Ms. Holt, perhaps we can approach this differently. Apex is prepared to offer enhanced severance terms. 30 weeks of severance instead of 18. Extended benefits continuation for 24 months. And a mutual agreement not to pursue litigation. In exchange for signing the revised separation agreement with the attached performance documentation and releasing Apex from all claims related to your employment and termination. Elizabeth and I exchanged glances. This was significant. They were essentially offering to pay me an additional 12 weeks of severance, approximately $85,000, to accept documentation that should have been provided initially. What's in the performance documentation? I asked. What specific deficiencies am I allegedly being accused of? Nolan turned his tablet toward me. 4 written documents, each from different Apex managers. Document 1 from Colin Reeves, Director of Supply Chain Operations, claimed I had failed to meet operational efficiency targets and created bottlenecks in the supply chain reorganization project. Document 2 from Ava Pierce, Senior Operations Manager, claimed I had demonstrated poor judgment during budget allocation meetings and refused to implement cost-cutting measures. Document 3 from Harold Brennan, VP of Manufacturing, claimed I had shown resistance to new operational methodologies and failed to adapt to changing business requirements. Document 4 from Owen Ashford himself, claimed I had consistently underperformed against key performance indicators and shown unwillingness to accept feedback. I read each document carefully. They were vague, nonspecific, and critically, none included specific dates, specific incidents, specific metrics, or specific examples of the alleged deficiencies. These documents are completely generic, I said. Colin claims I failed to meet efficiency targets but doesn't cite a single specific target or metric. Ava claims I showed poor judgment but doesn't identify which meeting, which budget, or which decision. Harold claims I resisted new methodologies but doesn't specify which methodologies or when this resistance occurred. And Owen claims I underperformed against KPIs without identifying which KPIs or what the actual performance data showed. The documentation reflects overall performance patterns rather than isolated incidents, Nolan said. Patterns without a single specific example. That's not documentation. That's character assassination. Ms. Holt, Diane said, her voice taking on a more conciliatory tone. Regardless of documentation specifics, the reality is multiple managers reported concerns about your performance. Leadership determined these concerns warranted termination. We're offering you generous severance to resolve this amicably. Why complicate this unnecessarily? Because I didn't underperform, I said flatly. Colin Reeves reported to me for 3 years and never once raised performance concerns until 3 weeks ago when Owen Ashford became CEO. Ava Pierce has worked with me for 7 years without complaints until suddenly she's documenting poor judgment. And Harold Brennan, I stopped looking at the document again. Harold Brennan hasn't worked at Apex for 5 months. He resigned to take a position at a competitor. How is he providing performance documentation about my current work? Nolan's expression froze. Mr. Brennan provided the documentation based on his observations during his employment. Mr. Brennan left Apex before Owen Ashford even joined the company. He couldn't possibly have observations about my performance under Owen's leadership, which is supposedly when these performance issues became termination-worthy. You're using testimony from someone who wasn't even present during the relevant time period. Elizabeth was typing rapidly on her laptop. Mr. Schwartz, using a former employee who left the company months before the alleged performance issues as a witness significantly undermines the credibility of this documentation. A jury would have substantial questions about why Apex couldn't find current employees willing to provide documentation critical enough to justify termination. Mr. Brennan's employment status doesn't invalidate his professional observations about Ms. Holt's performance patterns, Nolan said, but his voice carried less conviction. Actually, it does, Elizabeth said. Because it suggests Apex couldn't find current managers willing to provide sufficiently critical documentation. So they reached out to a former employee who has no current knowledge of Ms. Holt's work. That's not proper documentation. That's desperation. We're not going to debate the validity of the performance documentation, Liam Callahan said, trying to regain control of the meeting. The offer is on the table. 30-week severance, extended benefits, mutual release. Ms. Holt needs to decide if she wants to accept it or pursue litigation that will be expensive and time-consuming for everyone. We'll need time to consider, Elizabeth said, standing. Ms. Holt will respond to your offer within 72 hours. We left Apex's offices at 11:17 a.m. In Elizabeth's car, she turned to me with a slight smile. They're terrified. Did you see how quickly they tried to move past the Harold Brennan issue? They know that using a former employee who wasn't even present during the relevant time period is going to look terrible in court. So what do? We investigate. We find out how many other people Apex has terminated for vague performance deficiencies without proper documentation. We build a pattern and practice case showing this isn't just about you. It's about systematic policy violations. Then we take them to court. Over the next 3 weeks, Elizabeth's firm conducted extensive discovery. They contacted former Apex employees through professional networks and social media. They requested public records from state employment agencies. They reviewed court filings from other employment disputes involving Apex. What they found was damning. In the past 4 years, Apex had terminated 34 employees for performance deficiencies. Of those 34 terminations, 23 had been classified as requiring performance improvement documentation under company policy. Of those 23, only 6 had actually included attached PIP materials at the time of termination. The other 17 had been fired without the required documentation. Most of those 17 people had signed separation agreements and left quietly. But 5 had hired attorneys and filed EOC complaints alleging discrimination. 3 had settled confidentially. 2 cases were still pending. More importantly, Elizabeth discovered a pattern. Nearly every performance deficiency termination had occurred within 8 months of a new executive joining Apex's leadership team. The new executives would identify experienced employees as resistant to change or legacy mindsets, and work with HR to manufacture performance allegations that would justify termination without having to admit it was really about cost reduction or management preference. Owen Ashford, the new COO who terminated me, had done this at his previous employer as well. Elizabeth found court records showing he'd been named in 3 wrongful termination lawsuits at his prior company, all alleging he'd fired experienced employees on fabricated performance accusations. 2 cases had settled confidentially. 1 had gone to trial and resulted in a verdict against the employer. "Marin, I think we have enough to file," Elizabeth said during a meeting in early December. "We can demonstrate that Apex has a pattern of terminating employees for performance deficiencies without following their own policies. We can show that Owen Ashford specifically has a documented history of this behavior. And we can prove your termination violated both company policy and basic procedural fairness. What are we asking for? Reinstatement with back pay. Or in the alternative, substantial damages for wrongful termination, reputational harm and emotional distress. Plus attorney's fees. I'm thinking we start at $3,400,000 and see what they counter with." We filed the lawsuit on December 3, 2024, in Massachusetts Superior Court. The complaint alleged breach of contract. Apex violated its own employment policies by terminating me for performance deficiencies without providing required PIP documentation. Wrongful termination. The performance allegations were pretextual. The actual reason for termination was Owen Ashford wanted to install his own team and I was viewed as resistant to his changes. Defamation. The vague performance allegations damaged my professional reputation in the corporate operations industry without any factual basis. Violation of public policy. Using fabricated performance allegations to terminate employees violates Massachusetts public policy protecting workers from retaliation and false accusations. The lawsuit requested $3,400,000 in damages plus reinstatement or front pay. Apex's response came 4 weeks later. They filed a motion to dismiss, arguing that I had signed a separation agreement that waived all claims. Elizabeth filed an opposition arguing that the separation agreement was invalid because it didn't comply with Apex's own policy requirements for performance terminations. The hearing on the motion to dismiss happened in February 2025 before Judge Christopher Young. Both sides presented arguments about whether the separation agreement was valid. Nolan Schwartz argued that I had signed the agreement voluntarily and couldn't now claim it was invalid. Elizabeth argued that an agreement that doesn't comply with the employer's own written policies is not a valid contract, especially when the policy was specifically designed to protect employees from exactly the kind of arbitrary termination I'd experienced. Judge Young asked the critical question. "Mr. Schwartz, if Apex's policy requires performance improvement documentation for performance-based terminations, why wasn't it attached to the separation agreement Ms. Holt signed?" "There was an administrative oversight, Your Honor. The documentation existed but wasn't attached." "If it existed, why wasn't it attached? And if it didn't exist at the time of termination, how can Apex claim the termination was properly documented?" Nolan didn't have a satisfactory answer to that question. Judge Young denied the motion to dismiss. This case raises genuine questions about whether Apex followed its own policies and whether the separation agreement is valid when it omits required documentation. These questions should be resolved through discovery and potentially trial, not dismissed at this preliminary stage. That ruling changed everything. Discovery meant Apex would have to produce documents showing how they handled other performance terminations. Depositions meant Owen Ashford would have to testify under oath about why he fired me. Trial meant a jury would hear about Apex's pattern of firing experienced employees on vague performance allegations. In April 2025, we received Apex's settlement offer. $1,700,000, no admission of wrongdoing, mutual confidentiality agreement. It's a significant offer, Elizabeth said. About 4 years of your salary plus damages. But it's also exactly half of what we asked for, which suggests they're still hoping to minimize this. What do you recommend? I recommend we counter at $2,900,000 with no confidentiality clause. If they're serious about settling, they'll come up. If they're not, we go to trial and let a jury decide. We countered at $2,100,000. Apex came back at $2,100,000. We countered at $2,600,000. They agreed. The final settlement, signed in May 2025, included $2,600,000 payment to me. No admission of wrongdoing by Apex. Modified confidentiality clause. I couldn't discuss specific settlement terms, but I could discuss the general nature of my claims and Apex's policy violations. Agreement by Apex to review and revise their termination policies to ensure proper documentation requirements are followed. Agreement by Apex to conduct third-party audit of recent performance deficiency terminations to identify potential policy violations. Most importantly, I retain the right to discuss my case publicly for educational purposes regarding employment policy compliance. If you love this story about an operations executive who used her own policy language to expose her employer's systematic violations, subscribe now for more stories about using documentation and attention to detail to protect yourself. Hit like. Comment what you would do if fired for vague performance accusations. And turn on notifications so you never miss when understanding your own employment policies becomes your most powerful weapon. Do it now. 7 months after the settlement, I received an interesting phone call from William Crandall, who'd been on Apex's board of directors during my termination. Marin, I wanted you to know something. The third-party audit you required as part of the settlement found significant policy violations in how Apex was handling terminations. 17 employees who'd been fired for performance deficiencies without proper documentation. The board has approved a remediation fund to compensate those employees for the policy violations. How much? Approximately $5,800,000 across all affected employees. Your case exposed a pattern that was far more extensive than anyone realized. Owen Ashford has been asked to resign. The entire HR department has been restructured. And we've implemented new oversight procedures to ensure terminations follow proper documentation requirements. Why are you telling me this? Because your lawsuit did more than get you compensation. It forced us to fix a broken system. Employees at Apex are better protected now because you refused to accept a separation agreement that violated policy requirements. In late 2025, I started consulting for other corporations on operational best practices, including how to structure employment policies that protect both companies and employees. My experience at Apex became a case study I use in presentations about why documentation requirements matter and what happens when they're ignored. The lesson isn't just about reading your employment agreement carefully, though that's important. The lesson is about understanding that employment policies exist for a reason. When I wrote that performance improvement documentation requirement into Apex's policy 4 years before my termination, I was protecting future employees, including myself, from exactly what happened. Vague performance allegations used as pretexts for firing people management didn't like. By the time Apex realized their administrative oversight in not attaching PIP materials, they'd already accepted my signature on an invalid agreement. That oversight cost them $2,600,000 in settlement to me, plus $5,800,000 to other affected employees, plus Owen Ashford's resignation, plus a complete restructuring of their HR policies. All because they didn't follow their own rules. Let me share something else that came out during discovery. something that made the entire situation even more disturbing. Elizabeth's firm subpoenaed Apex's internal emails as part of the discovery process. What we found in those emails revealed the deliberate nature of what had happened. 3 weeks before my termination, Owen Ashford had sent an email to Grace Stevens and Diane Kelton with the subject line, Q4 Cost Reduction Strategy. The email read, "We need to reduce operational overhead by $2,300,000 before year-end to hit board targets. Recommend targeting senior operations staff with highest compensation packages. Maren Holt, $280,000 base plus bonus, is top of list. She's resistant to the new efficiency initiatives anyway. Let's move on this quickly. What's the cleanest termination path?" Grace had responded, "Performance-based termination requires PIP documentation per policy section 7C. We don't have current PIPs for Maren. Creating documentation now would take 90 to 120 days minimum." Owen's response, "Don't have that kind of time. Can we use past performance reviews? Or general feedback from managers?" Diane had chimed in, "Legal will want something in writing to justify performance termination. Can we get managers to document recent concerns retroactively?" Grace, "I can reach out to Colin, Ava, and Harold for written statements about performance concerns." Owen, "Perfect. Get those statements and let's move forward. Keep this tight. Don't want her getting advance warning." That email chain proved several critical things. First, my termination wasn't about performance at all. It was about cost reduction. Owen needed to cut $2,300,000 from the operational budget to meet board targets, and firing senior staff was the fastest path. Second, they knew they were supposed to have PIP documentation. Grace explicitly mentioned the policy requirement. But instead of following proper procedures, they decided to fabricate documentation after the fact. Third, they deliberately tried to keep this quiet and move quickly to prevent me from defending myself. When Elizabeth showed me those emails, I felt vindicated and disgusted simultaneously. Vindicated because it proved everything I'd suspected. Disgusted because it showed how little Apex valued the careers they were destroying. "This changes the case significantly," Elizabeth said. "This isn't just policy violations anymore. This is deliberate fraud. They knowingly terminated you without proper documentation, then tried to fabricate documentation afterward to cover their tracks. Can we use this?" Absolutely. In fact, this moves us from wrongful termination into potential punitive damages territory. Punitive damages are awarded when conduct is particularly egregious. Deliberately violating your own policies to commit fraud in order to fire someone for cost reduction? That's textbook egregious conduct. We amended our complaint to include the email evidence and add a claim for punitive damages. We increased our damages demand to $4,800,000. That's when Apex's settlement offers got serious. Within 2 weeks of filing the amended complaint, Nolan Schwartz called Elizabeth with a new offer, $3,200,000. "They're panicking," Elizabeth told me. "Those emails are devastating. No jury is going to side with Apex when they see executives openly discussing how to circumvent their own policies to fire someone for budget reasons. Should we take it? That's your decision. But I think we can get more. Those emails show deliberate fraud. A jury could award substantially more than $3,200,000, especially if they include punitive damages." We countered at $4,200,000. Apex came back at $3,600,000. We countered at $3,900,000. They accepted. The final settlement, renegotiated in June 2025, included $3,900,000 payment to me. Written admission by Apex that my termination did not follow proper company procedures and should not have been classified as performance-based. No confidentiality clause whatsoever. I could discuss everything including settlement terms. Agreement by Apex to revise their cost reduction policies to explicitly prohibit using terminations as a primary cost-cutting mechanism. Agreement by Apex to implement mandatory training for all executives on employment law compliance and proper termination procedures. Personal letter of recommendation from the board of directors acknowledging my contributions to Apex. The written admission was crucial. Most settlements include no admission of wrongdoing. But the email evidence was so damning that Apex agreed to admit they'd violated their own procedures. That admission meant I could use this case as a reference point when discussing employment policy compliance with other companies. More significantly, it meant other Apex employees who'd been terminated under similar circumstances could use Apex's admission as evidence in their own cases. Which is exactly what happened. Within 3 months of our settlement becoming public, 6 more former Apex employees filed lawsuits alleging wrongful termination with improper documentation. All 6 referenced the written admission Apex had made in my settlement. All 6 cases settled within 4 months for amounts ranging from $380,000 to $1,200,000. The total cost to Apex of Owen Ashford's cost reduction strategy? Approximately $11,700,000. In settlements plus legal fees, plus the cost of restructuring their HR department, plus Owen's resignation, plus the reputational damage of having multiple wrongful termination lawsuits become public. All to save $2,300,000 in operational overhead. The mathematics of corporate stupidity never ceased to amaze me. But here's what really struck me as this all unfolded. The number of people who reached out to me privately with their own stories of being fired on vague accusations without proper documentation. A former colleague from another company who'd been terminated for attitude problems with no written warnings. A friend's spouse who'd been fired for cultural fit issues after 15 years at a tech company. A former classmate who'd been dismissed for strategic realignment 3 months after reporting ethics violations. The pattern was everywhere once I started looking for it. Companies creating vague termination categories that didn't require documentation. HR departments that had forgotten their own policy requirements. Executives who viewed experienced employees as expensive obstacles rather than valuable assets. What my case proved was that those policies exist for a reason. The documentation requirements I'd written into Apex's procedures weren't bureaucratic red tape. They were protections against exactly what Owen tried to do. When companies ignore those protections, it costs them. Financially, legally, and reputationally. I started speaking at HR conferences about employment policy compliance. My presentation, titled, The $11,700,000 Email. Why Documentation Requirements Matter, became one of the most requested sessions in corporate HR circles. The core message was simple. Follow your own policies. If your policy requires documentation, create the documentation before you terminate someone, not after. If you can't create proper documentation, maybe that's a sign the termination isn't justified. During one conference, an HR director asked me, "But what if we have a legitimate performance problem but the manager never documented it properly? Do we just keep a bad employee because of paperwork issues?" "No," I said. "You implement a proper performance improvement plan going forward. You document the issues. You give the employee a genuine opportunity to improve. And if they don't improve, then you have proper documentation to support the termination. What you don't do is fabricate documentation after the fact to justify a termination decision you've already made. But that takes time. Yes. It takes 90 to 120 days typically. Which seems long until you compare it to the years of litigation and millions in settlements that come from improper terminations. Apex learned that lesson the expensive way. Another person asked, "What should employees do if they think they're being fired improperly?" Read your separation agreement carefully. Every page. Every clause. Look for what's missing, not just what's there. If your company has policies about termination procedures, check if those procedures were followed. If they weren't, document it immediately. And consult an employment attorney before signing anything. The truth is, most people don't do this. They're overwhelmed by the termination. They're worried about money and health insurance and finding a new job. They sign whatever is put in front of them just to get it over with. I understood that impulse. But I also understood that taking 35 minutes to read that separation agreement carefully and noticing the missing appendix materials changed everything. It turned a standard termination into a $3,900,000 settlement and exposed a pattern that protected 17 other employees. That 35 minutes was the most valuable time I've ever spent reading a document. Let me talk about something else that happened during this process. The personal cost of fighting a wrongful termination lawsuit. The money was significant, obviously. But money wasn't the hardest part. The hardest part was the professional reputation damage. When word got out that I was suing my former employer, some people in my industry viewed me as trouble. Litigious. Difficult. Someone who couldn't just move on. I had job interviews where I could see the interviewer's expression change when they asked about my departure from Apex, and I explained I was in active litigation. Doors closed. Opportunities evaporated. The hardest part was the